others who indicated they might be here as well. Just to remind people to turn their phones off, it interferes with their recording equipment. Agenda item 1 is apologies. We've received an apology from Stuart Dixon. Sammy Douglas, I think, won't be able to make it either. Any other apologies? Nope. Okay, agenda item 2, minutes for the meeting held on the 16th of April. If you look at pages 5 to 11 of your packs, if you want to just indicate if you're happy enough for me to sign off the minutes. Okay. Agenda item 3, matters arising. An updated forward work programme for April and May is at pages 13 to 18 of your meeting folder. If I can get agreement for a short meeting on Tuesday the 12th of May at lunchtime to deal with statutory rules and written papers, that'll free up the afternoon of Thursday the 14th of May for the business crime event that we're going to have. It means we don't have to have a formal meeting after that, if members are happy enough. So that's just a note. Item 2 is a response to the Committee on Procedures. Draft response to the Committee on Procedures on the pilot project to test a procedure for the management of draft affirmative statutory rules laid by the Attorney-General is at page 3 of your tabled pack. And just to remind you, at last week's meeting, the committee discussed correspondence from the Committee on Procedures requesting views on the pilot project and whether the process could be refined by omitting the establishment of an ad hoc committee. Members agreed that the scrutiny of the draft affirmative rule in accordance with the normal procedures adopted by Assembly committees had worked well from the viewpoint of this committee, and that we're still of that view, previously expressed in April 2014. It was difficult to envisage any role for the committee in proposing or responding to debate in plenary on such statutory rules, and it was agreed that a draft response on this basis would be prepared for consideration. So, if members are happy enough for that draft response. Yeah. Okay. Move on then to our first oral briefing. Is agenda item 4, update on Desert Crete. Just remind members they'll find the relevant papers, pages 21 through to 99 of your meeting folders. And then, if we can invite. Can I welcome Deputy Chief Constable Drew Harris, Chair of the Programme Board, Brendan Smith, Acting Director, Central Procurement Directorate, and Rosemary Crawford, Deputy Director, Policing Policy and Strategy Division. Just to remind you that the session is being Hansard and will appear on the committee website on due course. So whenever you're ready, Deputy Chief Constable, if you want to brief us, then we'll open up to questions afterwards.
Okay, well, thank you very much. I'll provide just a further update on the written update that you've been provided and was sent to you on 17th of April. And as you will be aware, on the advice and recommendations of the Programme Board, the Northern Ireland Community Safety College Steering Group commissioned a 2-stage review to clarify the training needs of all 3 services in the financial climate that we found ourselves in last year. The terms of reference were shared with you in December of 2014. Stage 1, we established the implications of the procurement process and to define the scope of Stage 2. Stage 1 was completed and the findings were considered by the steering group on the 25th November 2014. The purpose of Stage 2 was to re-examine the training requirements of all 3 services, bring forward options and recommendations as to what would be appropriate, affordable and deliverable in the current budgetary climate. An interim report was provided to the steering group at the end of February, detailing the Programme Board's assessment of all training needs as estimated by the 3 services, and that report was considered and endorsed by the steering group then on the 2nd of March. On the basis of that report, the Minister of Justice, the Minister of Health, Social Services and Public Safety have jointly circulated a draft executive paper seeking agreement to the Programme Board's recommendations and on the way forward, and this matter is now currently with the Executive for consideration. At this moment, without prejudice to any decision that the Executive may make, the Steering Group has also asked the Programme Board to begin developing a revised business case, and this will identify a range of options for the future delivery of service training, including an option that assumes maximum delivery of sites and premises currently owned by the services and, of course, the Policing Board, and that includes Desert Crete. In preparation for that, workshops will be held, objectives agreed and constraints and will inform the option appraisal that will go forward. The aim is to deliver a final business case by the end of the year to enable required funding to be sought in the year 2016-17 spending review process. Some of the detail of this then, when a training needs assessment was carried out, this concluded that the projected number of training days to be delivered at the college had reduced very significantly, and it's by the order of 48% reduction, and that compares to the requirement set out in the extant business case. The change was brought about in part by the financial environment and the constraint then on all three services. The budgets have been reduced and the size of the services is therefore impacted, and that impacts upon recruitment levels and overall headcount. All three services feel that particularly acutely as we have no means of getting rid of our staff other than natural wastage. So when you're reducing headcount in financially straitened times, it is by reducing recruitment. As well as that, and over the last 4 to 5 years, obviously, budgets have been constrained. All of the services have been responding positively and proactively to that. There's been a focus then on cost reduction, and that's included minimisation of travel, minimising abstraction, minimising the backfill and overtime required by abstraction, and optimising the use of the current facilities. There have also then been changes in the way in which training is delivered. IT is starting to play an increasing role, and so you have podcasts of training, but also then online training as well. And so those technological developments have also had an impact on reducing the overall number of training days required. Also then, it has to be said that in delivering those efficiencies and benefits so far, those have duplicated some of the projected efficiencies which would have been delivered by having a central college. So some of the efficiencies promised by developing a college have already been delivered just by, in effect, us all looking at our processes and driving costs out of those. The view shared by the accounting officers of all three services is that the project needs to be reframed to take account of our financial position and also then changes in methodology around the delivery of training. And it was therefore then only right and proper that the accounting officers, both of the departments and the three services, take seriously their responsibilities for safeguarding public money and reflecting this in their recommendations. The project continues, and it continues to be underpinned by the three pillars of affordability, value for money and procurement. These are fundamental to good governance and building a college. Development of the Joint Training College for the Police, Prisons and Fire and Rescue Services remains a programme for government commitment, and the DOJ and DHSSPS ministers have jointly put a paper to executive colleagues seeking their agreement on the next steps and the way forward. Those are my comments.
Thank you very much. Just before I open up to the members, you mentioned about the view of the three accounting officers that the project needs to be reframed. What exactly does that mean, and is it a way of saying that this project isn't going to happen at all?
Well, at this moment in time, we, the Programme Board, have been tasked with developing a range of options, and the business case that has been undercut by the change in training days. So we will have to revise that business case to reflect the size of the services, new methods of delivery, and just the efficiency and effectiveness that we want to find in delivery of training. And so we've been mandated around a series of options, from the due minimum to an option that assumes maximum of delivery of training at sites and premises currently owned by the services and the Policing Board. And again, as I've said, that includes Desert Crate. So our immediate priority is one, to assess the condition and suitability of all of the services' current training estate, and then that will agree objectives and constraints to inform the option appraisal as we go forward, and all of this will form part then of the revised business case. But a lot of work has been done around training needs. A lot of work has been done around how training will develop into the future. And if I can give just one small example, our student officers, who we've been recruiting over the last 9 months, 4 weeks prior to arriving in the training centre, they are given an online theoretical training package which they complete in their own time, but that does have an impact on training days in comparison to what we've been doing 10 years ago, or indeed in the time of the publication of the Patten Report.
Patsy?
Yeah, thanks very much, Chair, and thank you for being with us here today. It's one of those, and from the area, and I represent the area, and it's one of those you just get to the point of pondering the imponderable here. First thing, this is going ahead at all.
Well, we're still a programme board for the delivery of a Northern Ireland Community Safety College. We have been asked now to look at the business case and produce a revised business case with options within that. And so I can't definitively say whether this is going ahead or not at this moment in time. We have to work through the business case, follow that process, and see then what the options that meet the requirements around affordability, etc.
And I have to ask this because he said it in his capacity in response to a question from myself as Deputy First Minister. Mr McGuinness did say during question time that he had been aware from the very beginning of the project that there was opposition within the police service to it going to County Tyrone in the first place. And he went on to say that those people who were opposed to it were actually trying to undermine a programme for government commitment. How can you reflect on that comment in the context of what you know to be the case?
Well, I would entirely refute those comments that are directed towards the police service. This is a joint project. It involves all 3 services. The recommendations and the report that has been submitted to the Executive is a considered opinion of 3 accounting officers for those services and the 2 accounting officers for the relevant departments. So it is very much a shared view. I think we have demonstrated our commitment right from the very start to Desert Creek in the process by which we purchased it and have held on to it. So that illustrates that we wanted to be there. We have been through a process which has lasted now a number of years. It's got us to this point, but it doesn't actually, in our view, we are being asked to revisit the business case against these new facts.
Yes.
And that's what we've been asked to do, and that's what we will deliver. There is no agenda other than the affordability and best value and the delivering of training for the 3 services. That is the agenda at play.
So, from your point of view, you're clearly stating there is no opposition within the PSNI to the project going ahead at Desert Crate.
No, there's not, no.
Right. That's good to clarify that. Thank you for that. Then, could it come along to the 30 million end-year flexibility? That's probably your bailiwick, Mr. Smith. Now, and you're aware that I've submitted an AQ on this one.
It's probably not me. I'm now in DFP, and it's probably.
Oh, sorry, I thought you were a health.
Rosemary. We're a health projects division within CPD, but I don't represent the Department of Health.
All right, that's right. You've moved over. Well, maybe you could answer then, could you, Rosemary? The AQ, you're probably aware that I submitted the AQ, and you're aware of the response, and it's consistent with what is being said in the papers that they've got here before us today, the briefing papers. Now, I'll read the wording to you. There is no agreement to EYF carrying into the 2015-16 financial year. Just for clarity, has agreement been sought on it being carried into the 2015-16 year for this project? For this project now. Okay. Not talking about other stuff.
Any decisions around the carry forward or use of EYF are matters for DFP and Treasury.
Yes.
DOJ officials have been talking to colleagues in DFP, and they are aware of what the EYF pot had been, and that there was a 30 million element of that.
Yes.
That had been money that the Executive had provided to cover the health element of the project. So officials are aware of that. DFP officials will continue to engage with HNT to seek to reclaim that allocation for reallocation within the 15-16 year.
That wasn't my question, and I appreciate your answer. My question was, has agreement been sought to allocate this 30 million EYF specifically to a policing project, a policing college project? Is that specifically what the agreement has been sought, or are you seeking for disbursement of that 30 million elsewhere?
I'm not personally privy to the conversations between DFP and Treasury, but my understanding is that we have made them aware that that 30 million had related to this project, and that it was money that came from the executive,
yes,
and that we were keen to recoup that money, to reclaim that for allocation within the NI block. Where that would end up being spent would be matters for DFP and the executive.
Yes, and I would be very surprised if they weren't aware that that's what the 30 million was for, to be honest with you. But to get back to this, so you're not aware if DFP has sought agreement with the Treasury. Now, I've been asking this for about 4 or 5 months now. You're not aware if DFP has sought agreement with the Treasury for that 30 million to be rolled over for a policing college or a community safety college project. You're not aware?
I'm not aware. My understanding is that they have sought to get that money back to the NI block grant. What happens to it then, if that is successful, and hopefully it will be decisions for DFP and the executive.
And that would be for expenditure elsewhere. That could be it gone.
It could be in the, whenever the options appraisal exercise in the revised business case that the Deputy Chief Constable has described has been worked through, there will be a need to find funding for the project, for the preferred option, and that will be an executive decision. So they will be thinking about that in terms of the 30 million.
So essentially, whenever you, Mr. Harris, come to put your project together with the input of, you could be another 30 million down, and the 30 million could be a way off to, I don't know, where else within the executive. That's potentially what I'm hearing.
Well, that's the potential of it, but we, as we said at the moment, do not know that for a definite fact.
Right. Okay. Chair, I wonder, through whatever mechanisms we establish from DFP through the process, just what agreement they have sought about this 30 million, if in fact they have sought agreement for it to be extended into the 2015-16 financial year for this, or for a project akin to this, a community safety project, and if that agreement has been sought or approved or granted or likely to be granted, or if it has gone elsewhere. If we could, please, Chair, if that's okay.
No problem.
Okay, thanks, Chair.
That's it. Edwin?
Yeah. During the inception of this project, we heard a lot about training tourism. Is there any realistic prospect of training tourism being a considerable element of what you're currently looking at? Or is that merely a pipe dream?
It's not a pipe dream, but neither is it. Neither would it be a considered element. There is certainly people prepared to provide to pay for the training that we, the police service, could provide, and undoubtedly the other services. But in the overall scheme of running a college and the overheads, it would only ever be a small proportion of income that could be generated. Certainly, there's a lot of interest at the moment around, for instance, our command protocols and command training, etc. And that has been reported into the policing board. But in the end, it would be a small portion.
Okay. So you're indicating at the outset that the number of officers that you as the police would be training, that requirement has reduced significantly. The training tourism element of it is changed considerably. Therefore, the entirety of the project needs to change considerably. And the project that was initially being aspired towards is not something which, irrespective of programme for government commitments, could be fulfilled. It couldn't be supported by any accounting officer in that respect.
Well, we've been required to revise the business case on the basis of the facts that we have at this moment in time around our training need, training requirement, and I've set out the reasons for that. Training, police training, but training for all the services has changed and continues to evolve, and it's moved on very considerably from where we were in the publication of the Patton report, for instance.
What expressions has the fire service made regarding this matter?
In respect of
The Desert Creek project, as went out to tender, is that something that they would still desire to be involved with?
Well, yes, there's still a commitment from all three services towards joint training, and in fact probably the imperative around that continues to grow because cost reduction, cost savings, there is further efficiencies that can be made around sharing premises and sharing some of our training, and we have a requirement also to train, do some joint training, command training with the fire service. So there is an ongoing commitment by all three services to joint training.
I was asking less about the commitment to joint training, to more about the project that was originally conceived. My understanding would be that the fire service would not be supportive of proceeding with that type of project now, because number one, it exceeds what they actually need, and number two, it will cause them significant financial problems in terms of meeting that training requirement, the costs associated with it, which would consequently lead to a reduction in the manned fire stations, which would be somewhat counterproductive. I just think we have to be open and honest about these things, and I think even for Mr McLone's constituency we need to be open and honest. If we're not able to deliver this project, we need to come out and say we're not able to deliver this project. Now, I get a sense that you're looking at a Desert Creek 2 model, you're looking at something you could do at the existing training colleges, you're looking at a do-nothing option, which isn't really an option, and are you looking at a fourth option of a scaled-down project on an alternative site? That's something that you're giving consideration to?
No, there is no consideration of an alternative site. All our options will be based on the existing estate as it is at this moment in time. I think in just pointing out, the rigour which we have applied to the governance of this, the facts have changed, and subsequently then we've reported those, and as a result of that, well, now without prejudice of course to the executive decision, we are going through a revised business case process, and so it would be wrong, and in that process we will work up what the options are, but the options are already constrained. We're not going to seek an alternative site, and obviously then we're constrained within the estate we have, and that includes Desert Creek. But the revised business case process will in the end work through a number of options, and we'll present that in turn to the steering group.
But your training requirements roughly half of what it was whenever you initially envisaged Desert Creek?
Yes, the training requirement for all three services is 48% less than was originally envisaged.
Mm-hmm. Again, I think it's in the public interest that we quickly identify an appropriately scaled project, where we can go out to the public and say this is what we're doing, to ensure that we have the quality training for key emergency service personnel, and actually get on with it, as opposed to treading very carefully as not to upset people because of political considerations, but actually just get to the facts of what we can actually deliver and get on with it. Thank you, Chair.
Okay. Raymond?
Thank you very much, Chair, and thank you for the presentation. And perhaps the first question isn't really for today, but has there been any outcome of the investigation into the process which led to the first crisis in relation to the overshooting of the budget?
In terms of the what we reported previously, the poor performance of the design team, that's a process that's ongoing. I don't think we can say a whole lot about that at the moment, other than it is something that we're giving very serious consideration to. We're taking legal advice as to how to pursue what losses they have accrued and what may be recoverable in relation to that. But other than that, there's not a lot more that we can say about that process without prejudicing it.
Okay. Is there a timeline? Is there a particular timeline?
Well, we're actively pursuing that at the moment. We don't have a timeline for the end date of that, but it's something that we're active on at this point in time.
No, because one of the initial problems which has led you to the review is despite the fact a large amount of money being left aside for ring fence, was that we overshot a budget.
That's absolutely correct.
Okay.
Yes.
No, and if anybody was looking at if affordability is one of the pillars, then one of the ways to guarantee the failure of something is to make sure you overshoot your budget.
Yes.
And that's as we go forward in relation to what are we putting in place to protect us again in a large project like this, is that you say to someone they build something for £100 million, and the conclusion they did is that we can't do it because we can't afford it because the price is £120 million, where you could say, well, what can you do for £100 million?
Yes, I think there have been lessons learned from the process. We, I think, previously reported on the fact that the design team held their hands up and admitted that they were at fault, that they had poor cost management of the whole design process, and that led directly to the difficulty with the initial tender process. We have looked at that to see how we can strengthen that. Whilst we will always be reliant on the professionals to give us accurate professional advice, there are steps we can take to scrutinise that more closely in the future. I think that's something that we would take on board.
But would it be accepted that there was a failing in the proper supervision not being there in the first instance to detect it?
Well, I think we've learned lessons from it. I wouldn't say that there was necessarily a failing. There's obviously been a failure of the process, without doubt. There was good governance, a lot of good governance around this process, but the principal cause of it was we were let down by a design team who failed to manage the production of the package within the cost constraints that we had given them. I think there's a stage where you can have checks upon checks. I think clearly with hindsight, had we interrogated that further, but that's measured against the pressures to advance the project as well and to meet programmes, and there was issues around the availability of the funding within the current spending review, which was pushing us in one direction. But I think we have learned lessons in this particular process where it is unique to a sense. In other areas we have better base data on the cost of different elements. In this case we probably didn't have that because of the specialist nature of some of the elements of it, so that left us a little bit more vulnerable.
Yeah, but I mean, if people are suspicious or have fears or concerns, this was a project that people wanted to run in the sand, then this isn't a good example of how you would do it.
Yeah, I think there's no doubt that everyone associated with the project is hugely disappointed at how this has turned out. A lot of people have put a huge amount of effort and are really disappointed that this hasn't succeeded. But there has been good governance. There's been a review of the governance, and that has supported the fact that there was good governance around the project. But we can always learn from these sorts of episodes to make sure that we try to mitigate those issues in the future.
Okay, and the process going forward in terms of, it seems a surprisingly high reduction in training days in a short period of time. Even from the inception of the project.
Yes.
Even in the number of briefings we have had over perhaps the last year, I would say, in relation to this, there was never no sort of sense that you were facing that dramatic reduction in training days.
In part driven by the financial position we find ourselves in that has demanded that one, we do less training. And so we have actually, weeded out and winnowed out a lot of our courses, and we've taken it down to what is essential. Secondly, the reduction in recruitment has an impact. A lot a lot of our training days were around training officers as they arrived. There's a block of 22 weeks of training, and that's considerable. Once you start multiplying that up by factors of 100, there's a considerable amount of training days are tied up in that training. Consequently, when you start trimming it back, then your days fall away literally by the thousands. And also then, a lot of the mandatory training we have to do for officers around safety training, health and safety, some of the refresher training, and we have found it better, more cost effective to send the trainers out to stations and then an effective, a captive audience, rather than all our staff travelling around, and that incurs extra costs. So there's very sort of practical things to drive out costs, has driven down the number of training days, plus then the arrival of technology, but also then there's a drift, and I think it's the same for all the services, where the theoretical elements which can be learnt before joining, there's an encouragement throughout the world about doing that, so people in effect pre-qualify for lots of services, not just police, fire service and prison service.
No, I accept that, but I mean, that's something which you could have predicted. So when you were doing the first model for the scale and size of this, then you could have predicted some of the reduction. Therefore, it even makes it, the overshoot of £100 million budget, that type of figure today, less than 2 years on, just makes the whole thing look, what was nearly at the back at one time is now increasingly looking bad, because some of the measures which you're saying could have been done as you were making your first projection for this project.
Well, 2 years ago, even a year ago, we were fixed at a number of 6963, and that had been submitted and had been accepted both by the Policing Board and DOJ as a number of officers required for our operational commitments. The change in financial position has moved us off that number, and that's the practical reality of where we are. We have less officers than that, and that is through natural wastage and slowing down recruitment. We didn't anticipate that. Also, we hadn't recruited anybody from 2011, and when we restarted the recruitment process, we really reinvigorated it. We moved to a new training process, and that was redesigned, and in doing that we looked to what was happening elsewhere, and then we could see the difference about, in effect, preloading officers before they arrive. That's made a difference. And lastly then, there's just the issue about winnowing out the training courses and then changing the delivery of them. And another lastly is technology. At the time the patent report was published, I didn't even have a computer on my desk, and now training is delivered by podcast and e-learning, and that is a huge, that is taken out a lot of the training days that would have been anticipated otherwise.
No, I accept as far back as patent, but patent thing was there should be a centralised training college, a facility. But I don't think patent had any sort of blueprint of the size and scale. But the people who sat down to design it, and were given £100 million, and now we're told that there could have been measures put in place in terms of preloading, doing some of the training off-site, etc., etc. Notwithstanding, none of us perhaps could predict the austerity and what that would have. But they add up to 48%. It seems that's fairly dramatic. That's half of your training days. So therefore, it would add to my argument, if I can say that, is that the people who were setting out to design it should have had 3 or 4 options in place. So if you have £100 million to build something, somebody should have an idea what you can get for £100 million, £80 million, £60 million, never mind overshooting. And then when you add in, well, if we have only £100 million, we might have to do some preloading of the training. We may have to farm some of the training back out into the divisions rather than in the college. But we're sitting here today, managing through what's just is descending into something that's not going to work or happen.
Well, the main reduction, as I've already outlined, is around the recruitment of officers, and we couldn't have anticipated that. The other elements are more marginal. It is the change in the recruitment profile which is a major driver of this, and this isn't something we anticipated or would have planned and it is driven by the finances, as
No.
you highlighted yourself. And in some ways, some of the elements of the college were very fixed, and so, you know, the practical training facilities they're difficult to scale down in that you need the facility, whether you're pushing 200 through or 400. You know, the facility has to be able to be fit for purpose for the officers who are being trained, and that's the same for all these services. You create a facility, it needs to be fit for those who are going to be trained and go through it, and it's the volume that has changed, not the nature of the practical training.
And just, and again, it might be for today, is there a breakdown of the percentage, say, for the downturn in recruitment? They don't know the impact of technology.
Well, there's quite a lot of detail, and perhaps the best way of dealing with that is if I write to the committee, and I can set out the specific detail of that, because each of the services is in a different position around this.
That's lovely. Thank you.
Okay. Paul, and then Patsy.
Yeah, thank you, Chair. Yeah, just remind me again then, where do we go from here? What's the next step for all three agencies and indeed the steering group?
The next step is to revise the business case based on the information that we've learned through the governance that we are presently within, the new facts that we have in front of us, and revise that business case. All three services, as I've said, are committed to joint training. All of us see benefits in that, and indeed that's an imperative going forward to save money and around the issue of affordability. So we are committed to that. There has been benefits already, really, from working together and, you know, find commonalities and thinking where else that we can collaborate and share services. But our job, and through the programme board, is to look at options, revise the business case, report to the steering group, and also then, but we also await then the executive decision as well in their direction.
The Minister, when he was here in November, stated that the next steps for him at that stage was within 2 weeks. They would establish the present position regarding what was the current procurement process and firm up the scope of the second stage. The second stage was to look at the training requirements in detail.
Yes.
Regarding affordability, value for money, and procurability. That's all complete, is it?
I think it was the findings of stage 2 which were so stark. We did expect some reduction. It's when we had a close analysis of what that reduction was that's when the figures became so stark, and it was in the order then we found of 48%. That scale of reduction had not been anticipated.
I suppose we in here would look and seek reassurance. This has been a shambles of a process from day one, and whilst the cogs in government turn slow, and multi-agency programmes and teams and steering groups, I'm sure that the cogs turn even slower in different paces. But what hasn't turned slow is business and the dangers out there for business in the private sector, and there's no doubt about it. This whole shambles of a process has put good, decent businesses, some of which are in my constituency, at severe risk. They've spent a lot of money in tendering, and they are going to be left with nothing except the failed legacy of a tendering process. What sort of crumb of reassurance can you give us that, one, whatever happens in the near future, whatever thing is designed, wherever it may be, whether it be separate or together, that procurement processes, tendering processes will be fit for purpose and allow the private sector to actually tender for them and not be at massive risk even when they're awarded a contract, and that then something can be delivered that will be fit for purpose in the training scope of the 3 agencies.
Well, I maybe take the procurement side of your question
Yeah.
first there. No, I think, the points you make are points that we feel acutely. Fully appreciate the efforts and the cost associated with tendering these major projects and the commercial hit and the disappointment whenever nothing materialises out of it. And I think it's quite right to say reputationally for us it's damaging. It's damaging for the industry, and it's something that we certainly do not want to be part of. I wouldn't say that that's down to the process itself. I think there are a number of factors resulted in that, and we have been over those factors at previous hearings. The principal reason, I repeat again, for the failure of this tendering process was the mismanagement of cost control in the process by the design team, and that's something we are addressing. We will certainly put in further checks and balances in the future in terms of assuring ourselves that any pre-tender estimate created by a design team is more thoroughly validated and checked.
But what will that look like? Because it's a nice fluffy phrase and words in all due respect. But what will those checks and balances look like?
Well, what we did in this process initially was to do a spot check of elements of the tender package before it was complete. And that spot check on those elements did give a reassurance, but there were some caveats in that assurance. And I think going forward, what we need to assure ourselves is we need to do a more thorough check, a more forensic check, and not to go to tender on issues which are caveated to some extent by a lack of information. So I think we need more robust procedures in there around those elements.
With regards to a more robust framework and procedure, will you have the personnel and the capacity to enforce that and to police it?
Yes, I believe we have. I believe we have that. Part of the there's a team within SIB that are the project team that are delivering this on a daily basis, and our role as COPE, setting the procurement strategy for it. We have merged with CPD, and I think that gives us more options, more strength and depth, and even at a time when there are possible reductions in staff numbers, collectively our whole strength is greater than it was. So I think we're confident that going ahead we still will retain that expertise and strength to deliver on that.
With regards to the going forward then in the training facilities, the actual training facilities for all 3 agencies, are you confident that we'll get something that is fit for purpose? Bearing in mind, of course, when you build something, it doesn't take it very long to become out of date. I understand that.
Well, in part, we're focused on our present estate and the condition and suitability of that in the first place. Despite this reduction, all 3 services do still require training and do require a lot of training for the members and officers of those organisations. That's ongoing. All 3 agencies, services, as I've said, do see the benefits of joint training, and that's something that we are all committed to, and something that I think will further develop. So the revised business case is to explore that out and evidence base what we need going forward.
But in a practical sense, what does joint training really mean? Is it sharing a classroom whereby the police will have it in the morning and ambulance service have it in the afternoon, or is there actual scenes and role plays that you have to do together? What does it look like? What does practical training look like?
Well, the skills required of the staff in each organisation are very different. So there's no pretending that there's a huge crossover of the actual practical skills on the ground. The skills required, fire, rescue, police officer, prison officer, are different. But there is joint training around major incidents, critical incidents, but then, as you've highlighted yourself, there's also the sharing of infrastructure, so that you get maximum value and efficiency from the infrastructure that you possess as well. So, and that's where some of the economies of scale are to be found, rather than infrastructure lying redundant. So that's what I mean when I say joint training.
Okay. Thank you very much, Chair. Thank you.
Okay, Pat said one back in.
Yeah, thanks, Jared. Just for a wee bit of clarity, in terms of the paper of recommendation submitted to the executive for discussion, how many recommendations were there in that paper?
The draft executive paper?
Yes.
I haven't got the paper in front of me.
All right.
So, wrong. Sorry, Rosemary.
Well,
can you-
just think if I maybe give
Yeah.
some information around that.
Yes.
Clearly, it is a draft executive paper. It is the property of the executive, and it wouldn't be appropriate for us to go into detail on that. It hasn't yet been accepted by the executive for discussion, so it's still subject to change at any point in time. But I think it is fair to say that the paper outlined, similarly to the update that we gave to the committee, it outlined the current position in terms of the project. It sought approval to proceed with the work on a revised business case and sought approval for funding from the block grant in the event that the preferred option that emerges from that business case is for a cross-service college. There were a couple of other smaller technical recommendations in it that were of a commercial nature that wouldn't be appropriate to go into.
Just in light of what you said earlier, Mr. Harris, maybe I picked you up wrong, but you were committing to training facilities within the police estate, which included Desert Crate. Do all of those recommendations commit to a project going ahead at Desert Crate?
That depends on the business case that we have to revise. We're producing a revised business case. Within the constraint within the business case is that we use the existing estate, which includes Desert Crate. So no new sites.
Oh, sorry, that's not what I'm asking.
But if you're asking, is one of the outcomes that Desert Crate isn't a site, I don't know yet, because we have to work through the options.
Right, no, that clarifies it for me. I just wanted to establish if, in fact, you had committed entirely to progress and construction on the site at Desert Crate, or if, in fact, as you've just outlined, it may well be subject to the decision of others, that it may be ruled out, which is a bit of a concern, if even that's being considered as a viable option at the department.
Well, it depends on that decision would depend on the integrity of the business case process that we enter into, and I've talked about that. The constraint within which we're working, I've set out, and that's the single constraint we have. But we have to produce options which meet our needs around affordability, etc.
And have you a time frame for that?
Well, the time frame is for this calendar year, looking towards then 16-17 for funding.
Right, okay, thank you for that. Now, you can appreciate, and Paul referred to it earlier there, and I think one of the worst things, I realise a good part of it was outside your control, one of the worst things ever done was the stakeholder event in town, the Glenavon Hotel, where all those businesses were brought in, and their hype and expectation around it, this was by the start, and then within 5 or 6 days buying the whole thing torpedoed. So credibility,
Yes.
credibility is probably at an all-time low around the project, but then you read the report this morning from the RICS, which refers to a worrying decline in capital projects and public sector expenditure on infrastructural projects too. And you're sort of saying to yourself, when are we going to actually have a decision here for people and for all those qualified, skilled tradespeople and engineers and all that are heading off in the boats and the planes overseas to bring their expertise to bear in other countries? When are we actually going to show something productive for them to do? And that's the big concern. I'm sure all of us share that. And we're reflecting back what people who are engaged in the construction industry are saying to us.
Well, if I suppose the overall point to make is that as public services, each of the services are within reducing financial position.
Yes.
And that impacts on our estate, and it impacts then on the maintenance or indeed new capital works. And that's an inescapable fact. Our police estate has reduced very considerably, and I'm sure that's the same for the other services, that there have been reductions there. What we've been asked to do is deliver a revised business case. that'll be within the calendar year. So whatever the outturn of that is, then that'll provide some clarity, hopefully,
Yes.
around what might be required in terms of capital work.
Then even on reflection, if you get the business case agreed and all that sort of stuff, you're back into the procurement stuff, and round and round we go round the mulberry bush. So you can forgive my degree of scepticism about the project and what has happened up until now. It's really, people are saying, can we just have a decision? No?
Well, we await the direction from the executive as
Okay.
well.
That's grand, thank you. Okay, thanks, Chair.
Yeah, Mr. Smith, Brenton has put in record twice today that you've been let down by the design team in this.
That's correct.
What was your checks and balances to identify that what the design team was putting to you before it went out to tender was actually right?
In terms of the facilities that were provided, or the design, or
Well, I think the tenders come in roughly 40 million. The lowest tenders come in 40 million over what was anticipated.
yeah, in the order.
So, were you anticipating the tenders coming in the price as a project team at the price that you'd identified? Or were you anticipating that 40 million?
What happened when the tender package was put together? There was a pre-tender estimate prepared. That pre-tender estimate was in the order of, I don't know the exact figure, but in the order of 101 million. And we had a series of reports from the design team in the year that preceded that, where the pre-tender estimate fluctuated roughly between 98 million and 103 million. And there was real anxiety at the start of the process about the quality of the cost management, and it was something that we attempted to address on a number of occasions and asked for support to that design team, asked for more local input into that design team, to make sure that they were reflecting accurately the current market environment in which they were working. I guess because we had that consistent series of reports, something in the order of 78 reports leading up, on a sort of monthly or bi-monthly basis, where there was a reasonable degree of consistency around that figure. We went to tender expecting that the tenders would come back in at around about that £102 million figure. It then came as a complete surprise to ourselves. And during that tender process, a number of tenders approached us and said, it's not possible to deliver this within the cap that you have put on it. So that it was only at that stage, in order to keep the project progressing ahead, we, by agreement with all of the tenders, removed the cap that we had and said, right, submit your tenders and we'll work on a bill of reductions and the procurement process.
So you said you had more local input into the actual design team side of things?
Yes.
Yes. What was that?
That was a number of local firms supporting. They brought on 2 local firms in support of the team that was appointed. One of the issues was about the specification of materials, to make sure they were properly specified, that the local market would understand them. And the other aspect was around the engineering side of.
And did they cross-check the bill of costs that had been developed by the design team against what they anticipated tender cap might be?
Yes, that was part of the remit of the consultants who we appointed.
So they coincided with the design team then?
Pardon?
They coincided with the design team. They thought the design team's costs were.
Well, the information that they looked at, they came back and said that those elements of the information, what we subsequently determined happened was that during that process there was further design creep through that tender preparation period that they were unsighted on and that we were unsighted on. So, to take it,
£40 million worth of creep.
Well, essentially it amounted to that. And the figure, I think the lowest tender was approximately 32 million above our initial pre-tender estimate.
There were 2 local companies that were involved.
2 local consultants that were involved. One was an architectural firm called Ostick and Williams, and the other was White Young Green.
Okay, thanks for Just one final question, Mr. Chairman. It's to Mr. Harris. Why are we absolutely fixed this time on lands that are currently owned or within the control of the services? Why at this stage are we not saying and putting out a tender or looking at putting out a tender to companies to design, build and hand over appropriate facilities at wherever those companies might consider to be best, and that may well be Desert Creek, it may well be Garnerville, it may well be elsewhere. Why are we attaching ourselves so fixedly to those existing sites whenever it potentially could get you a better outcome, a better deal, a more fit for purpose facility at a lower cost, by leaving it more open in a tender process?
I think given the extent of services estates and what we actually own and have control of without having to purchase additional land or real estate, that it makes good sense to look at what we have. And look, we have to review the condition and suitability of our existing estate, and that's part of the developing or revising this business case. And so, as degree of, in respect of the first sort of part of around affordability, given the extent of what we hold already, it would seem foolish to look outside that.
If what you say is correct, the estate, somewhere in the estate will come out top in that instance. However, if you allow the process to go outside of the existing estate and something else comes in at a lower cost, you haven't actually lost anything. This is the constraint within which we're operating as a programme board. And I understand that. I don't accept the logic of it, though.
Yeah, the steering group have asked, and this is, this is provisional and outside. Yeah. And it's all subject to subsequent decisions by the executive. But this seems a good, sensible way to proceed and try and develop something within this calendar year.
I would suggest that the project board would be best looking at developing a fit-for-purpose facilities that can develop the appropriate training at the best possible cost, and therefore more open, and that is left, the better opportunity there is of actually reducing the cost of the public purse, which has already suffered quite badly as a result of all of this. Thank you, Chair.
Okay.
Thank you.
Thank you very much.
Thank you.
Okay, members, move on to agenda item 5 then, refer to pages 101 to 236 of your meeting folder. Just to remind you that the legal aid for Crown Court proceedings cost rules around 2005 prescribes the remuneration payable for solicitors and counsel representing defendants granted criminal legal aid for cases in the Crown Court. Rule 20 of the 2005 rules required the Department to conduct a formal review of the levels of the prescribed fees and the rates of payment under the rules. The Department amended the rules in 2011 and has now led a statutory rule to make further amendments to the 2005 rules arising out of the latest review. The Committee has considered the proposals on a number of occasions and received evidence on them from Department officials, the Bar Council and the Law Society. On the 8th of October 2014, the Committee was briefed by the Criminal Justice Inspection Northern Ireland on its report commissioned by the Committee, which provided an assessment of the impact of the Department of Justice Legal Aid Reform Package. Following the briefing, the Committee discussed the proposed statutory rule and agreed upon division that it was content with it. The Statutory Rule 2015/215, which is subject to the negative resolution procedure, was laid on the 14th of April and will come into operation on the 5th of May. The Department has indicated that there have been no material changes to the policy content since the SL1 was submitted to the Committee, and the explanatory memoranda advises that the Department expects the rule will produce annual savings which will rise to around £7.7 million by 2017-18. The examiner on statutory rules has indicated there is no issues to raise with regard to the technical aspects of the rules. A number of wider issues in relation to these Crown Court rules have been drawn to the attention of the committee, and I have therefore asked the department officials to attend the meeting today to provide some clarification and further information. I'm very grateful that they've done that on short notice. Relevant papers for members can be found pages 5 through to 31 of the tabled pack. So if Mark wants to come forward, great. Okay, Mark, Patrick, very welcome to the committee. Again, just to advise that we're being Hansarded in due course. As I said, I'm very grateful you came up in short notice. There's been a number of issues that were raised to me and some other members in relation to this, and I just thought it would be useful if we were able to get some answers to them if we can. Just first of all, in terms of the issue of exceptionality, it's been raised to us about the difficulties around exceptionality. In what ways does the Department intend to address the issue of exceptionality in relation to these rules, given the judgments in both the Brownlee and the Burns cases?
Okay, well, thank you, Chairman, for the opportunity to come along and to clarify any issues and help the committee in its deliberations. We're very happy to do that. In relation to exceptionality, there have been a couple of challenges, or several challenges to the rules in respect of the specific fees which would be payable in very specific circumstances. The first and substantive challenge was the Brownlee case, which went to the Supreme Court, and the Supreme Court concluded, in layman's language for me, that as the rules applied to the specific circumstances of that case, it didn't meet the need. We have adjusted the rules as a consequence of that, and a rule came through in the course of last year, I can't remember the exact date, to put a specific fee in to address those circumstances should they arise again. The Burns challenge is very recent, and we received the judgment on it last week. We're currently examining that judgment at the moment, and the circumstances around the case to see whether or not there's a specific fix that we can put in that would apply, and there is a specific fix that we could apply to that case in order to meet the specific needs that have been identified. We're also, I think it's fair to say, given that there are a number of these challenges now, we're looking overall at the issue of exceptionality and whether or not we need to put a more general provision into the rules in order to address the potential for exceptionality, so that these things don't keep arising. Although I expect that at that stage the challenge will be to whether or not a particular set of circumstances actually meets the criteria for exceptionality. So we've just taken receipt of the Burns case. We're looking at how we might fix it specifically, and then separately, or in line with that, whether or not we need to bring in wider provisions for exceptionality, and those would be brought forward to this committee in due course.
Okay, thank you. One of the other issues that was brought to the attention of the department that was the implementation of the Legal Aid in Coroner's Court Act has unintentionally removed the Court of Appeal's power to grant legal aid. Now, my understanding is the department's accepted that is the case. Why have you not addressed that gap in this statute rule, and how and when would you intend to fix that gap?
Well, we haven't addressed that gap in this statutory rule because this relates specifically to the Crown Court rules, and that error which we made in the commencement order has only just come to light. We are working on a solution for that. We believe that we have the solution, and I think our aim would be to put advice to the Minister with the potential of correcting it as early as the start of next week. Okay. So, and it doesn't need, it wouldn't be appropriate to put it through in this statutory instrument anyway.
Just finally, we were given a copy of the Crown Court Rules Committee minutes, and in the minutes it highlights that a range of concerns were raised with the department in relation to the statutory rule. What's the department done to address these concerns? Have you changed the rule in any way, and perhaps could you tell us what level of engagement you've had with them in the lead up to it? Okay,
we've had two meetings with the the Crown Court Rules Committee, and the first meeting was very much them setting out their stall, and you'll be familiar with the makeup of the Crown Court Rules Committee, with a number of senior judiciary and representatives from the Bar and the Law Society. And the key elements of the Bar and the Law Society expressed the concerns that they had previously expressed to this committee at that meeting. Only the first set of minutes, as I understand it, have been published. There was a subsequent meeting where we provided clarifications, and I have to say that the Law Society provided some very helpful observations on the draft rules as they stood at that time, and we made some adjustments to the draft rules to reflect those issues. They didn't in any way change the policy which had been before this committee and agreed with this committee, but they related to the technical contents of the draft rules, and we made those adjustments. And we also sought to address the other concerns which had been raised before. And as a consequence of that, we have a letter from the Secretariat of the Justice Committee, effectively closing down that interaction, basically saying you're now aware of the Crown Court Rules Committee's views regarding the draft rules named above, and thanking us for our participation in the committee.
Okay. You'd mentioned earlier about the consideration being given for the issue of exceptionality. Why would you go ahead with the statutory rule if that's your intention?
Well, this statutory rule takes the existing provisions and makes adjustments to the levels of fees in response to all of the research which we had conducted previously, and that's setting out the framework and the standard fees which are being paid. If we need to make an adjustment in terms of exceptionality, that would be sitting above those fees. So all of those changes would be appropriate and need to come into play as quickly as possible in order to deliver the necessary savings against the legal aid budget. We certainly will need to bring forward a further amendment to address the Burns case, and if as part of that we deal with the wider exceptionality issue, then we would want to go through the process of consulting on that to make sure that we take on board the relevant views as we're doing that.
Raymond?
I mean, in relation to the legal aid to Court of Appeal, how did that come to light?
There was a gentleman in the bar called
Mr. Valentine, a practicing barrister.
A practicing barrister who reviews and provides a critique on the law, as I understand it, and he identified the issue and drew it to our attention.
Is it something that should have been seen previous?
Well, it's an error, so
yeah.
It was a mistake that went through, and yes, if we'd we would have preferred that it would have been identified and been addressed before it happened, but I think it relates to the complexity of some of the things that are included in that, and the fact that we are commencing the civil legal services provisions within the 2003 order, but not yet commencing the criminal defence provisions within the 2003 order, and that's an issue that we'll be returning to later in the year. So, I mean, it was a genuine mistake in terms of just looking at every single aspect and provision within that legislation and timescale.
And what's the mechanism that
Well, we're looking at a number of options, but one of the options is to commence the specific provisions in the 2003 order which deal with the appeals at that level.
And can that be made retrospective? You know, if someone...
Well,
the bar, are saying there was a case today, but the
case today was adjourned.
There's one pending on Monday.
But that's one of the issues that we'll be looking at over the next 24 hours to see how we deal with those cases which are in flight. But I think it's fair to say that legal aid for criminal appeals is granted after the appeal has been heard. Yeah. So it should allow the appeals to process up to that point, and then it can be adjourned until this is resolved. But as I say, if we can do this in the way in which we've been exploring over the last 24 hours, then we should be able to resolve it at the start of next week.
Okay, thank you.
Okay, thanks, Chairman. Look, sorry, go ahead, Patsy. Yeah.
Okay, thanks, Chair. Thanks, gentlemen, for your presentation today, but can I go into a wee bit more detail? You mentioned there, Mr McGuckin, earlier, the Law Society had provided helpful observations, and on the back of that you'd made some helpful adjustments, and that you had sought to address some of their concerns. Can you give us a bit of a resume as to what all that was?
And the concerns that they raised, and
the responses that you made to that, and the likes, please.
I believe that I have in front of me some of the correspondence that was involved in that. There were some technical issues in terms of the drafting of the order, where they'd identified some typographical errors and things like that way, which were there. We hadn't included in the draft order a change in the classification of 3 offences, where we had agreed that we would change the classification so that those particular offences would attract a higher fee, and we corrected that in the revised version. That was part of the policy that was agreed. I can't remember off the top of my head any other. There weren't any significant issues. It was largely down to the drafting.
So yes. It's not down to the substance of change.
No, absolutely not.
All right.
No.
Well, oh, sorry, I thought maybe it'd been something meaningful then. But then, I'm just reading through some of the briefing documentation here. Disability Action had flagged up a number of issues around the EQIA and concerns that they had on issues including legal support for victims, witnesses and offenders who have a disability through the Victims Charter and excuse me, the Registered Intermediary Scheme, but expressed the view that more could be done. Have you engaged further with Disability Action around those disability concerns?
Personally, no. What we have done,
department,
and I'm not sure in some of those specific areas about victims and so on, that work is ongoing, and I couldn't say hand in heart what has happened in relation to those areas. What I can say though is the material which Disability Action provided for us in response to this consultation, we've shared with the other people within my work area who are looking at the reform of legal aid, to ensure that those views are factored in as we're working through the processes, because these rules were really about the fees which were being paid to lawyers, and their views were wider than that in terms of the scope.
That's why this is wider, but this is going to affect Disability Action. I have tremendous respect for them.
Yes.
They flag up an issue. So I think, Chair, it would be helpful if we got a wee bit more detail around how the department, if it's other people within your department, have responded to that or have addressed that or tackled the issue. It'd be helpful to us.
No, that's fine. And
okay,
other members who weren't able to be here have asked for written clarification on some of those issues that we raised as well. We intend to meet on Tuesday shortly to address this. So if you're able to give us some written confirmation on some of the questions that we've raised, and if you said that some of the other stuff may be resolved early next week, hopefully by the time we meet, that'll be the case, and then the committee meets.
Sorry, just one point. I've noticed something here in our table papers. There's the Bar Council. Yes, the Bar Council have commissioned a survey by Ipsos Mori, and I think they're saying they're urging us, certainly as a committee, to allow time for them for key data to be provided to us. Are you aware of that ongoing study by them? On their behalf, I should say, not by them.
I understand that they have commissioned that survey. I haven't seen any outworkings of it yet, and clearly it'll affect the totality of the bar and the work that it does, and not necessarily be focused in on the issues which are affected by the rules which are here.
Well, I don't know. I don't know what's in it, and nobody knows yet, presumably. So, but anyway, thank you, Chair. Thank you.
Look, I appreciate how quickly you've come back to us and be able to come. I know there's also an urgency in this as well, to have this in time and place, to appreciate the savings that are planned in this as well. So if you were able to get back to us in writing with clarification on some of the issues, and as I say, the committee have agreed to meet on Tuesday, and they will get it resolved at that stage. So
Okay, very happy to do that, Chairman.
Thank you.
Okay, members, if we move on then to agenda item 6, SL1, the Crown County Amendment Rules, refer to pages 238 through to 262 of your meeting folder. The Department of Justice is proposing to make a statutory rule which will be subject to the negative resolution procedure to amend the Crown Court Rules Northern Ireland 1979 to provide for new court procedures in light of amendments to the Proceeds of Crime Act 2002 introduced by the Serious Crime Act 2015. The relevant provisions in Serious Crime Act 2015 are due to come into effect on the 1st of June, and the Department is seeking to have the court rules in operation for the same date. The new court procedures for which updated rules are necessary relate to applications for a compliance order, a new provision allowing the making of an order by the court which, with the purpose of ensuring the criminal confiscation order is effective, and applications for discharge or variation of a confiscation or compliance order. The Department has also confirmed that no issues have been raised by the Court Rules Committee and that the regulations have no negative equality or regulatory impacts or present any financial implications. So can I ask members, are they content with the proposed statutory rule? Okay. Agenda item 7. Can I refer members to page 264 through to 357 of the meeting folder? The Department has published the Strategic Framework for Reducing Offending in May 2013 as part of the Programme for Government Commitment 54 to reduce the level of serious crime. The Department has now provided a written report on progress to advance the strategic outcomes of the framework. The report provides an overview of the programmes, interventions and initiatives that have been implemented, steps being taken to evaluate early outcomes and key developments currently being taken forward. So again, can I ask members, are they content to note the strategic framework? Yep. Okay. Agenda item 8, Access to Justice Review. Can I refer members to pages 359 through 395 of the meeting folder? Just to remind the committee that at the meeting on the 15th of October 2014, the committee considered a progress report from the Department on implementation of the Access to Justice Review key findings and the projects outlined in the Departmental Action Plan. The committee requested further information on a number of the projects where slippage from the target dates had occurred, and this was provided by the Department. The Department has now provided a further progress report on the key areas and the projects in the Departmental Action Plan. Analysis of the report indicates that there is some slippage with a number of the projects. Details of these projects and areas where the committee may wish to request further information are set out at paragraph 5 of the Clerk's memo on pages 360 and 361 of the meeting folder. So if committee members are agreed, we will request further information highlighted at pages 360 and 361 of the meeting folder. Okay, agenda item 9, Programme for Government Update. I can refer members to 397 through to 423 of the meeting folder. The Department has provided an update on progress in relation to the 7 commitments for which it has responsibility in the Programme for Government. 4 of the 7 commitments have been assessed as on track to be delivered, 2 are broadly on track and 1 is not on track to meet the targets within the original Programme for Government period. The target that will not be met relates to Desert Creek Community Safety Training College Capital Project, upon which the committee has just received an oral briefing. So can I ask the committee, are they content to note the progress report in relation to the Department of Justice Programme for Government commitments? Agenda item 10, referring to pages 425 through to 545 of the meeting folder. September 2014, the committee considered a draft adult safeguarding policy jointly developed by the Department of Justice and the Department for Health, Social Services and Public Safety, which was due to be published for consultation. The committee agreed to consider it further when the results of the consultation and the final version of the draft strategy was available, at which time it would also schedule a briefing by the Commissioner for Older People, who had requested an opportunity to present the findings of her report, Protecting Our Older People, a call for adult safeguarding legislation. The Department has now provided the results of the consultation and indicated that the responses were generally positive in terms of broad policy content, and provided helpful suggestions to clarify or improve the policy, as well as identifying areas where some further consideration is needed. A range of views were expressed regarding the need for legislation to support the adult safeguarding policy, with a lack of consensus apparent across all sectors, including amongst some of the leading adult safeguarding organisations in Northern Ireland. The Department of Health, in liaison with the Department of Justice, intends to take time to further explore the range of views expressed and attempt to reconcile them. The Department briefing paper also outlines the views of the Department of Health, working with the Department of Justice on the specific legislative proposals that were set out in the consultation paper, having considered the responses received. Both both departments will continue to engage with stakeholders, and officials are currently finalising the adult safeguarding policy, which will be provided to the committee in due course. So again, can I ask members, are they content to note the results of the consultation and consider the final adult safeguarding policy once it's provided? Yep.
Yep.
Move on to agenda item 11's correspondence. There's 6 items of correspondence at pages 549 to 570 in the meeting folder, and 2 items at pages 33 and 38 tabled pack. Can I draw your attention to item 1, page 549? It's a response from the department in relation to the level of statutory bereavement damages in Northern Ireland. I think it's an issue that Patsy had raised previously. And the department has indicated that the availability of bereavement damages is a matter for the Department of Finance and Personnel, and the Department of Justice is responsible for setting the fixed amount of these damages. The department intends to undertake a review of the level of bereavement damages in Northern Ireland in 2015-16 and hopes to bring forward a consultation paper in the autumn. The committee had also requested clarification from the department on why the level of damages in Northern Ireland had not increased in line with England and Wales in 2013, but the response did not address this point. So members agree we'll maybe write to the department again and ask the question again, and hopefully we'll get the answer this time. Sorry, Paul.
Yeah, it just seems to be a very drawn-out process for something that I believe. Of course, we always talk about consultations, and of course it's always right to consult the public, but for something like this, you can't imagine that there'd be an argument in a consultation. To me, it would be very clear-cut one way.
Don't consult about rates on that. That should be in line with.
Yeah, I don't see how anyone would be against rising up to the same level as the rest of the UK. So it just seems to me strange that he's going to go into a whole process that will take months and months and months for this issue. So I suppose my question is why does he feel the need to go into the process of consultation?
Look, when we're writing to get an answer to the question that we felt wasn't answered, we'll maybe ask in terms of how long anticipated this process will last, and if there's any sort of legal requirement to go to consultation
yes,
on it.
that would be good. Yeah,
Thank you. Back. Okay. Item 3, page 556 and 557 of the meeting folder, is an invitation from Mr. Alban McGuinness on behalf of NACRO, inviting committee members to attend a seminar by the Director of the Scottish Violence Reduction Unit on Wednesday the 13th of May in room 115 here in Parliament Buildings, addressing offending behaviour and making communities safer. So if any member wants to go along to that, if you just advise the committee staff, and everyone's welcome to go. Item 4 to 558 of the meeting folder is an invitation from the Attorney General to committee members to attend an event celebrating 800 years of Magna Carta on Monday the 18th of May 2015 in his office in Belfast. I've agreed to go to that. If anyone else wants to go along, they're more than welcome. If you just let the committee staff know if you wish to attend. Item 1, page 33 of the tabled pack, is a response from the department in relation to the justice-related issues in the Special Education Needs and Disability Bill, which is currently in committee stage with the Committee for Education. The Department of Justice officials have been working closely with the Department of Education on the impact of the legislative proposals on the SEND Tribunal, which is administered by the Northern Ireland Courts and Tribunal Service. In general, the Department of Justice welcomes the proposals and recognises the value of introducing mediation services and committing the Education Authority to participate in mediation in cases where parents or children are willing to engage and enhance access to justice by extending rights of appeal. The Department has highlighted that the extension of rights of appeal does have the potential to increase the number of appeals coming before the tribunal, and it has some concerns about costs associated with an increase in business levels. Whilst these may be offset to some degree by an increased use of mediation, the Department expects any costs will be met by the Department of Education and has supported the policy proposals of the bill on that basis. So if I can just ask the committee content to write to the Committee for Education endorsing the proposals of the bill that are relevant to the Department of Justice, highlighting the possible increased costs, and that the Department has supported the proposals in the bill on the basis that the Department of Education will fund any increased costs, and provide a copy of that response from the Department of Justice. Yep. Item 2, page 37, is a letter from the Department regarding the consultation and the interim report of the review of the implementation of Welfare on Animals Act 2011. The consultation, which was due to end on the 23rd of April, has been extended until the 21st of May to provide additional time for the public to present their views given the recent concerns raised in relation to dog breeding. If members have any other issues to raise with any other correspondence? No? Okay. Agenda item 12, Chairman's Business. No business other to thank members for attending the just a seminar this afternoon. I thought it went pretty well. Feedback seems to be pretty positive. And again, we'll let you know the date of the next one and ensure that everyone is able to go to that as well. Then item 13, any other business? Any other issues to raise? No? Okay, then agenda item 14, date, time and place of the next meeting. It'll be next Tuesday then to look at the statutory rule that have been requested to get additional information on. It'll be quite a short and snappy
What
meeting.
time would it be, Chair?
We'll need to figure that out, probably over lunchtime.
All right, that's okay.
And we'll try to keep it as short as we possibly can.
Enterprise Committee in the morning, you see.
Okay, we'll try to make sure it doesn't clash with any other.
Okay, thank you.
Okay, thank you.
Is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room